Alright, there we go. It's working now. Yeah, carry on.
Right. Right. It was a very interesting hearing today.
Mm-hmm.
I felt very unusually tense. I mean, last night I didn't sleep at all. You know my situation. I am basically homeless because they have deprived me access to my former home and everything.
Yeah.
But I don't want to go on that point. The point is, I made two very strong complaints to the official judicial conduct because no member of the public were allowed in last time. This time, I was allowed to bring one person, and I expressly request that basically somebody to help me with the notes, basically.
Yeah.
You know, when you have the tension to focus on what to say, on to listen what you need to listen, it's difficult to take the notes at the same time.
Yeah.
And be concentrate on what you need to say. So finally, somebody was helping me with the notes. It was very useful. Also
Fantastic.
as a witness.
Uh-huh.
Now, the interesting point, the first thing I asked to the judge was basically because I received a notice of a hearing for today, basically, but it was only written the hearing has been adjourned. It was not specified what hearing had been adjourned.
Oh, we said it was adjourned.
Yes.
Oh my goodness.
And I was very surprised because a few days after the 27th of January, I had received the court orders basically against me, really, forcing the going ahead with the sale of the property.
Yeah.
So I was surprised that I received later on another paper saying that the hearing had been adjourned. So I asked the judge, first question before I can even talk, please explain me what hearing has been adjourned.
Do you know the name of the judge?
Yes, the judge, the name is District Judge Coonan, C-O-O-N-A-N.
C-O-O-N-A-N. Uh-huh.
Yes, and basically I've asked the first question, and I asked what hearing had been adjourned, because I had two important reasons to ask this question, which I'm going to explain now. The judge seemed to be a little bit confused with regard to what she answered later, because she said that the hearing had been adjourned was the hearing in which I was meant to discuss my legal notice to void the proceedings.
Yeah.
And I felt quite surprised because that was completely incorrect. I've never asked the hearing to void the proceedings. I sent a legal notice, and as far as I'm concerned, the proceedings were void as far as I'm concerned.
Yeah.
Based on the undeniable evidence that I had used together with my legal notice. However, the interesting point is that day there were two hearings in reality, to be correct. The first hearing was allegedly granted to myself as early as November. We are talking about the mid-November 2015. And that hearing was granted to myself to discuss basically the unless order to strike out the proceedings, which I presented on the ground of a lot of more evidence that I produced, basically.
Yeah.
In shortly, the claimant has never disclosed any information, never filed in any information, and more importantly, never served me with any information since the proceedings started. So I couldn't understand how the proceedings could go ahead almost 2 years now, and I was not even served a single shred of paper so far. So obviously I presented an unless order. And before that, I presented also a notice of admission, an application to force admission from the claimant on the ground of the evidence she's concealing to the court. To cut it short, so the first hearing was granted in November, And I said, I'm quite surprised that you say that the hearing that has been adjourned was the hearing to avoid my proceedings, because I've never received any notice of hearing with regards to that particular action. I wouldn't say application, action, because I only presented a legal notice, right? And I was never told I should have presented an application, and the void the proceedings legal notice was just dismissed, ignored, without further direction, as they're doing all the time that I presenting some important documents. So I said, are you sure that there was to void my proceeding? She said yes. So I said, I'm very surprised, because the hearing, as you can see, was listed for already in November 2015, but I never filed my void. I filed the void in February 2016.
Yeah.
And she was very confused. She began to be really mumbling. And I said also, why has the hearing been adjourned? She said, why you ask me this? Because I received, after the hearing on 27th, which I didn't participate, I received the court orders. So why had the hearing been adjourned?
Yeah.
I don't quite understand. It's contradictory. If you say it has been adjourned, she said, oh, it was the hearing, the other hearing for their less order now. It became the hearing of their less order.
It switched in the middle.
Are you basically telling me that there were basically 3 hearings, because also the claimant was granted a hearing the same day?
Oh.
So there was a hearing for their less order, a hearing to void my legal notice to void the proceedings, and another hearing for the claimant.
A triple word
And
score.
everything. Then she started really, I wouldn't say panicking, but she started mumbling, because she didn't know what to say. She was very confused. I got her in flagrant surprise, basically. And it wasn't an ambush. I was just simply asking questions that she couldn't answer.
Yeah, you want to clarify what's going on.
Exactly, because I don't understand. I said, so could you please give me, you say that you have dismissed my legal notice to void the proceedings. Can I know the legal grounds? Can I know what grounds? She just wouldn't give me the grounds. She said, because I think it wasn't relevant, she said. And I said, could you tell me why? And she wouldn't. So I insisted. I said, I object. I would like to have explanation, because first of all, the claimant hasn't paid the fee. And then she said, oh, really? And then she asked the solicitor on the other side, have you paid the fee? And they said yes. I said yes, but I haven't seen any evidence. And also, not only haven't seen any evidence, but it's clearly stated on the computerized court records produced by the court that the fee had not been paid.
No fee. So how can they have a case with no fee? That's impossible.
No, and now comes the beauty. Guess what the judge said? She said they're unthinkable. And I asked her to repeat it, but she didn't want to repeat it. I said, can we put this on record, please?
Right.
And she wouldn't repeat it. She said, oh, and even if the fee wasn't paid, they would give us a check today, isn't it? To the other side, to the solicitor. I said, what?
She's trying to patch up. She's trying to patch up fraud.
She's saying that even if they hadn't paid the fee, it would have been okay for them to pay the fee 2 years after the proceeding started.
2 years, yeah.
I said, are you actually saying that the proceeding went ahead without the fee being paid until now? Is it this that you're saying? I said, also, I have another confirmation. Where is the entry for the payment of the fee? Where is it on the record?
Yeah.
And she couldn't answer. She tried to brush my notification, my objection aside, yeah?
Yeah.
Then it came to the very interesting part. I I asked the judge, could you ask the gentleman, the solicitor or the claimant, could you ask if they ever served me documents? Because I since the case began, that I was never served with ever any document at all. She said, is it true, to the other side? And they said, I have served the documents on 16 February.
Yeah.
And I said to him, what year? 16 February, what year?
What year?
And he was forced to admit 2016. I said, so I'm right to say that I was never served with any document, right? And now she's trying to brush this other argument aside, which is an undeniable argument. No one can deny that.
Yeah.
And then I began to ask her. I said to her, can we put on record that I was never served with having any document whatsoever?
You had no service.
Said,
you had no
yes,
service.
Basically, basically, yes.
Yeah.
And I said, could we please look at the very first order of the court? And she wouldn't go.
That's strange. Isn't that strange? You're there to sort these problems out, and she's basically refusing to do her job.
Well, she was insisting to say, I'm only dealing with this application. I said, yes, but before this application, we had almost 2 years of casing going ahead on what? On what evidence has this case gone ahead?
Yeah, what due process?
Because the interesting point in up to this discussion is, could you please look at the very first order? And she just wouldn't accept I said, why? I'm only dealing with this application. I said, because the first order was produced on the 10th of July, and the case was allegedly issued on the 8th of July.
Yeah, amazing.
So 2 days after, we had court orders, but the interesting point is the court orders was asking the claimant to file and serve, which means they should have served me with a particular document, which they never done it. So obviously they are in contempt of the court orders.
Well, the order is not valid. It's dead then, isn't it?
It's dead. Well, for me, it's dead at the proceedings, not even the order, the entire proceedings, because I'm trying to establish whether there has been a due process, whether the case has ever duly been issued, right? So she wouldn't give me reasons why she dismissed my notice to void the proceedings. And then I said, what about the unless order to strike out the case, given that they have never served the disclosure, not even the disclosure required by the court orders? And she said, I dismissed it. I said, why? Because you are asking things which are not relevant. I said, which one is not relevant? He just admitted that he never served me with a document since the case began. So you're saying that this is not relevant to the case. Mm-hmm. And she would just brush me aside again. So I said to her, she said, Mr. Foglia, I will ask you to write an affidavit. You should have write a witness statement by today. Have you produced a witness statement? I said, madam, I have produced a sworn affidavit on 27 of October 2014, before the very first hearing.
Yeah.
And she said, can you look it on the court file? And she wouldn't find it in the court file. I said, I know. Mm-hmm. This is not the only documents which disappeared on the court file, particularly my document, and particularly the most important document, which is my main first affidavit. I said, why is it not on the court file? She wouldn't give me an answer. So I said, if the claimant has not served any evidence whatsoever, and if my affidavit was not in the court file, how these orders have been produced in October 2014?
Yeah.
And she wouldn't be able to answer. She'd not be able to answer. I said, I'm only dealing with this application, Mr. Fogg.
Yeah, so they're sidestepping the crime.
Before this application, we had 2 years of undue process, which I'm trying to understand.
Yeah,
every time I file evidence, my evidence disappear on the court file, and the other side is being allowed to go ahead without having even serving me a single shred of evidence, or even basically basically complying with the court orders itself.
Yeah.
So I insisted in the due process, and I said I'm sorry, I object, and you don't seem to have jurisdiction, and the court doesn't seem to demonstrate that he has good jurisdiction on this case.
Yeah.
Because there is no due process. And after that, she said, "Okay, shall we adjourn the hearing?" And then she said, we'll meet in half an hour.
Wow.
So the other side, in the meantime, when we came out, she said, when we came out, we will deal with your unless order, the judge.
Yeah.
In that half an hour, I was approached by the other party.
Wow.
I was offered £40,000 to basically shut up and disappear. And I said, no, excuse me. I'm not interested in that. I want the full. First of all, I can't discuss that only if the claimant will make a full admission. Will basically rebut my affidavit.
So who offered you the 40 grand?
About my conveyance.
Who offered you the 40 grand? The solicitor or the
solicitor?
Jesus Christ! I wonder how much they offered the other people, like the J. What do you call these people again? It comes back. They offered him 40 grand. How much did they offer the other people, the other crooks in the chain? Jesus Christ. But you see, once they start doing that, yeah? Hi. You there? Modern technology. It's as bad as the court.
Hello? Hi. All right. Thank you very much.
Hi.
No, I haven't checked it yet, but yeah. All right. Thank you. I'm just at work at the moment.
The claimant will make full admission with regard to my conveyance, because I need to know the truth.
Yeah.
I said, unfortunately, I had 10 years in that horrible situation, and I need to know the full truth about the conveyance, which she arranged, unfortunately.
Yeah.
So, and then we can discuss that. Also, I've been deprived of my home. It's 1 year, more than 1 year, I'm homeless, basically. On top of my 10 years that I spent in that trap. So, interesting point, we came out in the courtroom, and since we came out in the courtroom, I wasn't able to make a single point. The judge just spoke to the other side. She didn't let me question anything about the court records. She would just deny, brush me aside, everything, and I was forced to object. I said, objection, I'm objecting this, I want to make an oral submission. I want to make an oral submission under oath right now in the court. And she would just deny me. She wouldn't make me do the oral submission.
Wow.
She just went ahead the way she wanted. She produced the new court orders, and she would just not allow me to make any oral submission. She would just say, okay, you can put it in writing for next time.
What next time?
The next time there's going to be a hearing, the next time I should comply with her new set of directions. But I'm simply not going ahead. Until the court will show me there is a jurisdiction, I will simply keep on not complying with any order. They have to show me that there is jurisdiction from the court. I want all my objection, all my points addressed before it going any ahead.
But it's amazing because they are committing crimes and abusing their power, which is a serious crime in itself and can carry a long jail sentence. And then if you then try to make your point, they will say you're have threatening behavior, contempt of court. They want to put a civil restraint order. So they're putting one crime on top of another. You're the victim. They try to offer you money, which is, you could call it an out-of-court settlement, or you could call it a bribe, depending on which way you look at it. And you don't know who else they're offering money, and what else is going on. But it's clearly that, knowing a little bit about your case, Victor, that the rules are being broken left, right, and center for quite a long period of time. So, and it's going through a court of law. So how can these criminal activities be going through the court of law repeatedly, month after month, and the court of law doesn't do anything about the criminal activities and the abuse of the court process? Even the court fee to begin everything is a matter of theft.
Anthony, the problem is that, the issue is also that I reported everything to the enforcement authorities, namely the police. I reported the fact that the lock has been changed, and every time I go near the property I'm assaulted by somebody or some relatives of the claimant, and I reported these things, and I have now the certainty that this judge doesn't want to look at the facts. I asked the judge to consider the evidence which has been on the court file. She told me I can resubmit my affidavit, which is fine, but I want to resubmit the affidavit only because the court has lost it. I don't want to lose the benefit of that my affidavit was filed in October and has still not been rebutted. The claimant has not made any admission, and I said, if the claimant has not made the admission, bearing in mind, I issued a notice of admission because the claimant is disputing payment of the mortgage. She's saying I've made contribution. I said this is simply untruth. But if the court doesn't enforce this notice of admission, I'm very happy to flood the court with thousands of letters and emails proving that the claimant has not stating the truth, and that we obviously will increase exponentially the time and the resources needed for assessing this case, because I will produce thousands and thousands of pages, when in actual fact the claimant could just make admission. With this is included the cost, and my cost is going to be much bigger than whatever amount of money she might be able to claim. So if this is what the court wants, then I will give this to the court. I will flood the court with thousands of emails and thousands of letters proving my case. I didn't want to do that. It's going to be extremely distressing for me. I'm already homeless. I've already lost many documents, although I still can access in my friend's home all the files I need in several safe place, and that's it. And I will flood the courts with every single email I send the claimant with regarding payment or regarding time I spend on 15 court cases in the attempt to get repairs, to which she never contributed, all the legal expenses I incurred, and every single hour I spend writing letter, emails, and so on, and dealing with the extreme management of the property, which has been basically sold to me with no planning application, no completion certificate, no completion with compliance with basic compliance with health and safety. And I can definitely say I've been deprived of whatever a human being needs the most in his life, which is a safe, healthy home for 10 years. That's how I lost my job, and I became ill, and I had to face 15 court cases. But, all in all, I felt I really stood my ground in a very polite manner. And just a bit in the end, I got a little bit upset, because obviously the judge was not allow me to speak. I requested several times, and I objected the fact that she didn't allow me to make my oral submission.
Well, you
It's
see,
a very important thing to say, and now
it seems to be happening a lot. People spend hours and hours and nights, sleepless nights, and long periods of time making preparation, and they go to court, and the judge don't allow the evidence to be spoken.
well, this judge has got to be really careful
Children.
because she's ignoring what it cannot be ignored. Basically, she's ignoring the evidence adduced by the court itself, the computerized court records. The records and the file are defective. The court has got to explain why are defective and why this order being produced if the evidence wasn't on the court file. So I try to point out this essential, basic, essential, crucial kind of evidence, and the judge would just brush me aside. That's
right.
to me is being biased, and I will have no doubt in reporting the judge once again. So this is what's going on. I will ask because of my exception circumstances, so they made me homeless with this court case in a criminal matter. I will ask a copy of the audio. I wanted the audio today to prove that I've been criminally wronged, and the judge is simply brushing everything aside.
Well, it sounds like it's an abuse of process and an abuse of position and a misfeasance in public office altogether in one.
Absolutely.
Which are very serious. They're very serious crimes.
Absolutely, and I don't understand why the judge is brushing aside. I'm trying to point out, and I got the admission from the other side that they didn't serve me, and I said if they insist, I will ask. I want them to produce proof of recorded postage. I want to see what they send me and when they send me, because that's also a massive proof that the case went ahead in complete abuse of process.
Private hearings, section 52.5a. No, that's to do with transcript. You can get a copy of the CD under the CPR 52.5a. But the private hearings are not, what does the court say, not desirable?
Very interesting, you mentioning. I'll tell you why. I forgot to mention a very interesting detail here. From the very beginning, in front of the other witness who helped me with the notes, Stephen, basically, the judge said several times, I want to tell you that this is going to be a private hearing. I said, excuse me, why is it going to be a private hearing? And I said, I'm failing to understand. I said, once again, you're telling me that this is going to be a private hearing. And I said, why is it a private hearing? Because she mentioned the same rule, there are private financial information involved. I said, could you please explain me, what do you consider as private, so private that cannot be basically discussed in front of members of the public? What is it? He said, there are contributions that made toward the mortgage. I said, what is private about this? What is it? We're not a couple, we're not married, we don't have children together, there's no sexual connotation or interference.
There's no justification for a private hearing.
So why is this a private hearing?
But the other thing, Victor, very important here. Is it the judge who is talking about private hearing, or is it the other side?
No, the judge.
So the other side is not requesting a private hearing, but the judge is taking it on herself. Judge Coombs, DJ Coonan in Croydon Court. Is it Croydon?
Yes.
A lot of things happen in Croydon Court, doesn't it? So she's taking it on herself to basically exclude witnesses. That's what it boils down to, isn't it? If you're having a private hearing, what you're also saying is you're excluding witnesses from witnessing a possible crime.
I'm actually only trying to understand why is this considered private. It's a simple dispute between two parties trying to force the sale of property, but in reality it's a massive cover-up of a massive conveyance fraud, mortgage fraud. This is what in reality is about.
It's compounding,
And,
compounding of criminal activity. They start
yes.
with one crime and do another crime and do another crime on top of a crime, and then they rely on the gangsters working in the judicial system and the police to and other gangsters to back up basically nothing.
I want to say that in the past, because I had to face quite a massive amount of a number of hearings for this situation in last 11 years, roughly 15 or 16 different court cases. And which have completely disrupted my private life in a variety of ways.
It's
But basically,
harassment.
I have met judges who are really fair.
I would probably.
This is encouraging. This is encouraging because
Maybe the vast majority of them are upstanding people and they uphold the law in the way it's supposed to be.
Absolutely.
However, we tend to see the same names cropping up again and again when there is very clear black and white cases of fraud going on. Fraud upon the court.
I'll tell you, Anthony, I am not simply not moving an inch. I'm not retreating an inch. I'm standing my ground. They have to explain me point by point how this case went ahead in complete abuse of process, without the fee being paid, without evidence on the court file. They have to explain me every single point because there's so many points that they have cast very dark shadows on this case. And a judge who refusing to see that, I'm sorry, is not doing his or her job.
It's unbelievable. You know, Michael Gove, what's Michael Gove, the Lord Chancellor or something, Secretary of State for Justice, just sacked 69 people for pumping out, dodgy warrants out of the courts. And I think that's probably a lot more to come. So your case, Victor, it's involved so much. It's such a long chain of, fraud upon the court that nobody can come along and say this link in the chain is bad and this one. They're all basically finding different reasons to avoid acknowledging a single item. That's what I can't understand. They just. And each time it goes, each month it goes, there's more to cover up. The mountain gets bigger and bigger. I guess it's going to reach the point, Victor, where it becomes like Mount Everest, where you can't hide it. It's just there.
The judge has already said that she's going to proceed the next hearing, which is already the third hearing. The interesting point is that she said that she dealt with my unless order. She dealt with my legal notice to void the proceedings and dismissing both of them. She said also that she dealt with my notice of admission, dismissing that as well without any further direction, like they're doing all the time I file something. But this is not what the court told me. On the letter I received, there are the names of other judges. So obviously someone is not stating the truth. My
goodness. Judges lying? I don't believe you. Are you saying the judges are lying?
I'll tell you. I'm just saying that today I only used a few arrows of the one I have, and I didn't want to reveal too much. I just want to say, okay, let's make a couple of questions, and I could see the judge wasn't able to answer any. They were all brushed aside. And it'll be very interesting to know what she's come up with now.
Yeah.
I gave it the benefit of doubt that let's go in the courtroom today. Let's give it a chance to see whether or not maybe the judge itself has been misled. Maybe the judge hasn't seen the real file, and that's exactly what it is. I have responded. I have asked for an urgent internal investigation 3 times to the court manager, who allegedly is Miss Fiona Waller, and I haven't got any response from the main manager, who's basically the operations manager, and I'm still waiting for a response, because ultimately it's her court, as they like to say. She's responsible for this court, and I haven't got any response from her. I asked, can you please confirm that A, Y, X, and Z are in the court file, which is a basic reassurance that there is evidence on the court file, and I haven't got any response. So I will simply not accept this state, and I will go ahead. I will not move an inch until they respond me.
Well, you know, you've done tremendously well to stand up to the corruption you've been facing all these years, and it's so simple. I mean, they haven't paid a court fee, Victor, to even start the case. And am I right to say that one of the reasons the court fee isn't paid is because they're bypassing the proper court to channel it through a shadow court, and by paying the fee, it would have to be tied up in the accounting system. So that's why they avoid the fee. It's not about the money.
Well, this is what is possible to assume, but however, it's not up to me to say. The reality is that I have asked for a receipt as a proof that they paid the court fee, and nobody is able to give it, nor the court, and neither the claimant is able to provide a receipt. That's certainly a matter of fact. I've asked the judge to look at the computerized court records. She was kind of surprised, or she pretended she was surprised, that there was no fee being paid, and it actually was written on the record. There was no entry, which is the third confirmation that the fee has not been paid. And as far as I'm concerned, until I see the receipt, and a valid receipt, because if they say they use the check, they can tell me, okay, tell me what check, when has this been paid.
Yeah.
Give me the check number, and we'll find out with the bank.
Find me that code of a
But this is simply not happening, because the judge doesn't think this is relevant. To the point that she's as bold as to state, okay, even if the receipt has not been paid, they can pay tonight with a check. I said, can you please repeat that?
That's unbelievable.
Are you saying that the case went ahead almost 2 years without the fee being paid? Is this what you're saying? And she wouldn't answer.
But she's not just saying that, she's offering to cover it up.
It's quite unbelievable. I said, what about CPR 11? The court shall not take any step unless the appropriate fee has been paid. And what if you need to ask for a passport, would you get a passport without paying the fee? Or can I pay in a couple of years?
Well, you would at least have some document to say you got credit. But this is a complete fraud on the public purse, because
it comes in a time. It comes in a time when they are saying that they need to increase the fee because they are not making enough revenue.
Well, I tell you a joke. If you the probate fee, because we were just doing some probate work for someone, and the probate fee that's gone now from £249 or something, 200 and something, I think it's 249. It's now going, if you have a property worth a certain amount of money, you could be paying the probate fee of £20,000. An increase from 250 quid to £20,000. And these are the people who are robbing the public purse and robbing the court and bypassing the proper process of law.
I know. And also, if you need to issue a claim, let's say if you've been wronged the big way, the way you or me or other people has been wronged, imagine you have a little job where you earn £1,000 or £1,500 a month, which is hard to live with.
Yeah.
Then you need to pay a fee of £10,000 just to issue a claim.
Amazing. What they're saying is, no justice for you guys. And the
Well,
criminals are not paying the court fee.
The door to access the justice is basically locked, completely locked.
And the criminals are not paying the fees, they're bypassing it. And somehow the judges are standing firmly, the police. You did report this theft of the court fee to the police, didn't you, Victor?
Yes, I did.
And what did the police say again? Remind me.
It's a civil matter. Even my assault was a civil matter. I was assaulted outside the door of my previous home, and I've been assaulted, and that's a civil matter.
Oh my! Imagine if you went and did it and ran off and didn't pay the court fee and got some judge. You could. They wouldn't do anything, and they wouldn't process anything anyway. But just in theory,
I don't think I would got the first court order at all.
The police will be around and arresting you immediately. But now when the criminals are doing it, it's a civil matter. It's amazing. When the criminals are doing things...
They would not arrest me simply for the fact that they would say, we're simply not making any order unless you pay the fee.
Yeah, yeah. And on the court record that you have, the computerized court record, whenever you have paid a fee, it shows, doesn't it? You've paid a fee.
Yes, that's an interesting point. You see, I couldn't even discuss these things because the judge just shut the door and she wouldn't let me talk.
Yes.
But I've got a few ideas, and I'm going to put them in place, really.
Well, I think what is happening now, more and more people are picking up on this fee thing. And I think if everybody start to make a fuss about it and report it to the police, and it becomes clear to the courts that it's not just one or two cases, it's the norm. When criminals abuse the court, they don't pay the fee for some clandestine reason, and it's a matter that's an epidemic in this country and in these courts, and somebody in the government has to do something and restore the criminal damage that has been done to people and their lives, and let the gangsters pay.
Well, I had lots of trust in the institutions when I moved here, and a lot of admiration for the country, but a lot has been lost because my recent experience with the courts showed me a completely different world. I've been really trying to establish the truth on what happened in my fraudulent conveyance for 11 years now. I found out the truth after almost 10 years. But even when you have undeniable truth, they seem to be easy. Just so easy, just to brush people aside and cover up everything.
Well, I mean, it seems to have been going on a long time, but the only thing I can imagine that is going to blow up like TPI when they covered it for so long.
It is blowing.
It's blowing because we saw Michael Grove sack 69 people for sending out false warrants, and we see quite a few more and more people winning their cases on some of these things, but in proportion to the amount of it that's going on, it's a drop in the ocean, you know?
Oh yes. I don't know if you have heard of the case of more than 50 magistrates who basically resigned, as a form of protest, really, because they say so many people who's been wronged, they're not able to pay for the fee just to appeal in criminal courts.
Is it?
I say they are afraid to have further expenses against them. They are afraid that they can't afford the cost if they lose. They're basically intimidated to the point that they don't even try to defend themselves when they are innocent.
Well, this is what's going on. I mean, I've heard on Radio 401.
Really, really sad. This is really, really, really sad.
Yeah. It's.
But I'm personally going ahead. I won't let this stop me. I will not back up a single inch, Anthony. You know.
You've done well. You've held your ground, and you've refused 40 grand. I was gonna say bribe there, but you've received 40 grand, you refuse 40 grand. That's very good on you. He's a man of principle, and if everybody stuck to principle, you'd be doing some great work with your time and your effort, your energy, instead of fighting a unnecessary battle and clogging up the court system and allowing criminals to be roaming around in the society.
I've got no doubt that at the end the truth is going to come out, and I told very clearly to the other side, I will never sell that property to another family. I will always say the truth, and no person will say no mind would buy the property once they know the truth. But I told them it would be not me to sell that property. I don't want to sell that property. I would just want to say the truth to anybody. I went through the hell in 10 years, living in a house flooded for 10 years. I called the environmental health for help after 6 years and my house was flooded and infested with mold and damp and waterfalls. And Croydon Council, the environmental health, they just said, sorry, we're not getting involved in private disputes between leaseholders and freeholders. I said,
Yeah.
This is when I began to be really ill. Because I went really through, living in a house with heavy flooding for years and years and years. I assure you, it's not nice.
Well, look, man, you've had a long day. How long was you in the court for?
Oh, quite a long. I was in the court for 3.5 hours.
3.5 hours, and they still weren't able to